Yes, I wanted to know why workman's comp don't pay for pain and suffering.
That's a great question. I think I can answer it for you, and then I think Greg will confirm it. You have to remember that until lawyers got involved in the 1920s and 1930s, if people were injured on the job, if they broke their neck or were paralyzed or died, there was absolutely no compensation to those workers unless you could show there was some negligence by a company. In other words, if he just backed off the ledge and fell a few stories and was killed, there'd be no compensation to the families. So lawyers started filing lawsuits against companies for unsafe work environments. And then they were able to get full compensation for the losses that occurred. Well, then companies started saying, well, no, this is too much exposure, and they said, we need to work out a compromise. So the compromise ultimately has been this, just in real simple terms. In exchange for limited liability, no compensation for pain and suffering, if that worker backed off the ledge and fell 5 stories and died, his own negligence could not be used against him. The only issue is whether or not it occurred during the course of employment. So this has been an ongoing development in the law, both in Georgia and South Carolina, and it's a compensation system that is working and gives some measure of protection to the companies, makes for a safe working environment, and gives some compensation to the injured workers. So that was a great question. Greg, you agree? You got anything to add to that?
The one other thing is that 100 years ago, someone would have to find an attorney to take the case, file a lawsuit, litigate it, and pray the jury gave them enough money to compensate them.
Right.
And then the legislature figured this isn't working. These people are hurt, they can't get medical treatment, no income. So they devised this no-fault system of workers' compensation to provide authorized medical treatment and wage loss while the person's out of work.
Yeah, it used to be this would go on litigation could go on for years. Mm-hmm. And there would be no compensation to the injured worker until it was resolved in court. And of course, the defendant insurance companies would delay it as long as possible. So this ended a lot of hardship.